So anyway, so let me go through where we are and what's happened. We're still pretty much in the same position. We've been submitting packets. Speaking with the other attorneys, they've been doing the same. There has still not been any word from the trustee as to when they believe they're going to start making offers. Again, we're hoping that it's in the November, December range, but we really don't know. We've been working on a number of issues relating to liens because a lot of people have had issues with seeking any kind of medical attention. And if you do that and you have insurance or Medi-Cal, Medicare, any of those kinds of things, then there is a hold placed on your recovery. So we're trying to get those resolved in advance. So that's something that we're working on. We're also working on the 1099 issue. We had another call on that this week, and we're following up again next week. So that's the only updates that I have. I've got a number of questions, so let me answer those. The first question is, we would like you to explain the legal part of the trustee. I don't fully understand the question, so I can kind of go through and explain what a trustee is and where we are with that. In essence, the trustee is in charge of the trust and is responsible for making all decisions related to the trust, although they do have to check with our group, the Trust Oversight Committee, for any significant decisions and get our input. And then there's certain things that they have to get our approval for, like selling stock, those kinds of things. So the reason that there is a trustee is that when there's a bankruptcy, the money is funneled into a trust, and then it has to be paid out, and that's what's taking so long, is they're trying to make sure that this is done in a fair and reasonable way. And I think the big fear they have is that they're going to give away too much at the beginning, and they don't want to do that. So I think that's one of the reasons for the delay. So that's the essence of the trustee, although if anybody has additional questions, please let me know. Next question is, again, same kind of thing. We are having a hard time understanding the trustee being paid thousands of dollars per hour. That's an exaggeration, but certainly he is being paid a lot. To figure it out as he goes, is this legal? Again, it is. The problem is nothing like this has been done before, and so there wasn't someone that we could just go to who would have a blueprint. The way that they typically do it is by essentially doing it on a cookie cutter approach, very similar to a class action. That's not what we want because it's not fair, but it does take longer to do it this way. So next question is Miss Yanni finished with the wildfire assistance program? Yes, that has been wrapped up, so that's been done. Next question. You stated in a previous Zoom the trustee may break up the payments into 3. Will this mean we potentially end up going to neutrals 3 times? No. What that means is that and let me just break it down. So let me take a step back. What's going to happen is that there will be an offer from the trust that will either be accepted or you'll go on to the next stage, which is a more formal mediation or an arbitration. At some point, there will be what we're calling a final award. So let's say that's $100,000. Now the issue becomes, how is the trustee going to get that to everyone, because he doesn't want to wait until all awards have been determined in order to start making payments. He wants to be able to make the payments immediately. So the issue then becomes, how much does he hold back to make sure that he can pay everyone an equal amount? In other words, if there's only enough to pay everyone 75 cents on the dollar or 90 cents on the dollar or whatever that number is, he wants to make sure that he can do that in a pro rata basis. So no one receives an unfair amount. No one, the first person up doesn't get 100 cents on the dollar and the last person gets 50, if, for example, it's 75. So one of the things that was being discussed was to make an initial payment of whatever it was going to be, 30%, 40%, just so that some money could be given to the claimants, and then at the next stage, make the payment for what they thought was going to be the full amount, again, whether that was 75, 85, 90, whatever it was, and then if there was any left over, make a third payment. That was something that the trustee was toying with. Whether they'll do it or not, I have no idea. My guess is no, but that was the basis for potentially there could be 3 separate payments. I think that's unlikely. I don't think that'll happen. I think it'll be 2, but that is the possibility. Now, if that does happen, determining the claims amount, the final claim amount, will only be done one time, so there's not an issue of going to 3 neutrals. Next question. With next month being the 2-year anniversary of the Camp Fire and PG&E having already funded the Fire Victims Trust, when are the initial offers and distributions scheduled to be made? Again, we're hoping it's going to be in November, December, but we don't have any final determination of that yet. We do have a call coming up later this month with the trustee, so we're hoping to get some ideas on that. And then the last question I have right now is, I would like to put forth the name of a charity. How do I do that? Please just send me an email, and I will forward it along to the trust, and they'll come up with one there. So those are the questions that we have that were sent in. Guillermo, do you have any that were sent in by text or email?
Yes, Jerry, I got a couple here from the chat. Okay, once an offer is accepted, how long until the funds are dispersed and we have either a check or cash in hand?
It shouldn't be too long. Once the offer is accepted, then again, the payments are going to take place in at least 2 stages, because we don't know if there's going to be enough for everyone to receive 100 cents on the dollar. So that first payment, and let's just use 50%, that first payment of 50% will go out fairly quickly. Then the balance, again, hopefully it would be the remaining 50%, but it might be 25%, it might be 35%, it might be 45%, we just don't know. That will be made once the trustee has determined what the total amount is, so he knows whether there's going to be a pro rata reduction or whether everyone's going to get 100 cents on the dollar.
Perfect. Thank you, Jerry. Okay, follow-up question. The client indicated they have not received any requests from our law firm to sign off on any packet to be submitted to the trustee. They said that they spoke with someone a few weeks ago in regards to what they thought was a finalization. Should they have heard something by now?
That's interesting. The answer is it depends. And so the best thing to do is just to email the person you spoke to, or you can email Guillermo or me, and we can find out the answer for you. But initially, the first submissions, there was no requirement that the client or the claimant sign off. It was just, we signed it on their behalf after we went through it. So that very well may be what happened. If it was a finalized version and the attorney or paralegal was going through. All right, there's some background noise, so if you're not speaking, please just mute it. If the attorney and paralegal was going through the whole thing with you and then getting your approval to sign off, then that means it was finalized and sent in. So the easiest way to check is just to send us an email and we'll follow up.
Thank you, Jerry. Okay, another follow-up question. If we go to mediation and we don't accept the offer, how long do you think a trial date will follow? Like, what's the time frame?
Yeah, there's no trials because this is now, it's in bankruptcy. So the money's in the trust and there won't be any trials. What will happen if you do not accept the initial offer or the mediation is you then go to arbitration, and the decision is made not by a jury, but by a retired judge or some other neutral. There are some attorneys, but for the most part, they're retired judges that serve as arbitrators.
Perfect. Thank you, Dre. Okay, the last chat question is, do you think the stock will rise that we are to receive with this?
Yeah, the stock, and again, no one's getting stock. The stock is in the trust, but the stock already has gone up. It was at, I didn't check it this morning. Yesterday, it was at 1033, and it was, I believe, at 901 when it was issued. So off the top of my head, I don't know, but that would be a 15% increase. So 15% on, I think it was 4.2 billion, would come out to, what would that be? A little over 600 million that it would have gone up. Yeah, close to about 620 million that it will have increased since we got it. So that's a good thing. And obviously everybody hopes it keeps going up. The real test as to whether it's going to go up substantially is going to be after fire season. If PG&E can get through this fire season, which, as everyone knows, has been by far the worst in California's history, I think we're over 4 million acres now that have been destroyed. If they can get through this one without having started any major fires, and then post very good earnings for the first quarter of next year, which is the year-end earnings report, then everyone thinks the stock will go up substantially. We need it to get to about 14.5 to get to 6.75 billion. Obviously, we're hoping it goes to 17 or 18. If that happens, then there's no doubt everyone will be paid in full. And frankly, people may get more than 100 cents on the dollar, which we would do by awarding punitive damages. But we can cross that bridge, which would be a great bridge to have to cross when we get there.
Perfect. Thank you, Jerry. Okay, how many of Singleton's clients' claims have been submitted to date?
Several hundred, but how many, I don't know. I haven't checked that. It's Erica Vasquez is the partner in charge of that, and so she's the one that does it. We're submitting, we will be done within a few months. I think we'll be done before the deadline. And when they get paid, right now, we don't know. Again, we're really hoping it's going to be November, December. I know everybody's hurting, and on these TOC calls, that's our main focus, is getting this done. So again, I'm very hopeful that I'll have good news for you soon, but right now we just don't know.
Thank you, Jerry. And then another question was, who gets the upside of the stock increases?
The trust. So if the money increases, and it's the same thing with the third-party claims, as you know, part of the deal wasn't just for the cash and the stock, it was also that PG&E had to assign all of its third-party claims, which we're estimating are going to be worth somewhere between 500 million and $1 billion. All of those after, and the attorneys haven't been hired yet, but at some point the trust will hire attorneys to go out and get that money. They'll have to pay those attorneys, but once that money comes in, it then goes into the trust, and all of the claimants get the benefits of that. So again, the hope is that in addition to that 500, let's say conservatively 500 to 750 million, there is also going to be an appreciation of the stock. And if it can get to 15, 16, 17, then there'll be an extra 500 million, a billion, $1.5 billion. All of that will go into the trust, and it will then be paid out on a pro rata basis to all of the claimants. So any appreciation after the various fees are paid goes to the individuals. And by the fees, I mean the fees for the sale of the stock and those kinds of things. There are administration fees that the investment bankers charge. Unfortunately, there's no way to get around that. But after that, everything else goes into the trust and then goes to the claimants.
Perfect. Thank you, Jerry. Okay, and then another question was, is there any clarification on how attorney fees will be paid out?
No, there's not. The trust initially put out guidelines saying they were going to do it on an hourly basis. meaning that they were only going to award for reimbursement the amount the attorney put in. And as we explained, and on this, the Trust Oversight Committee, we were all on the same page. We submitted a brief. I submitted that to Justice Trotter about 2 weeks ago. That would be unfair because it punishes the claimant if their attorney did not do a lot of work. For example, we put in tens of thousands of hours on this case. And so on a pro rata basis, our claim is going to be a lot higher than somebody who hired an attorney who didn't spend any time on it or who spent very little time. And the point is, that's not treating the claimants equally. The way that it should work is that you should be reimbursed for the fee you actually have to pay. And so that's the argument we're making. We believe the law is very clear on that. And so that's what we're fighting about now, but we don't have any final word on that. If this does not work the way we want it to, then I think it is something we can appeal because it's a legal issue. So that's certainly something we would look into doing if it comes out and it's not something that we believe is sufficient in terms of being fair to all of the claimants.
Thank you, Jerry. Okay, a follow-up question. Are the victims of the first fires going to be paid out first, or does that not come into play?
No, it's first come, first serve. So there are not going to be any, it's not going to be, for example, Camp Fire gets paid last, Butte Fire gets paid first. It's going to be as soon as your claim is submitted and determined and they start issuing payments, then the payments are made. Now, that said, you know, we've submitted a lot more Butte claims on a pro rata basis. We had less clients, but in terms of our Butte clients, a lot of our Butte clients have already been submitted because their claims were already worked up. Now, there are some that, for whatever reason, they had to get additional information or, you know, something else, aren't submitted. But those claims were already worked up and ready, so it wasn't difficult to submit them. Generally speaking, claims are ready in the order that the fires occurred. So, you know, Butte claims from 2015, the Butte Fire in Calaveras and Amador counties, those are largely done. For the 2017 fires, you know, Tubbs, Redwood, Atlas, all of those, Sulphur, those are Cascade. Those are, for the most part, done. You know, not all of them, but most of them. And then Camp, while many of them are done, many of them aren't. And that just is, it's completely understandable. A lot of people haven't been able to get all of the information, whether it's personal property lists or whatever it is. And we certainly understand that. You know, we don't want to put any pressure on anyone, but typically it takes victims, and again, this is understandable, a while to get all of the information in. And so what we find is that the more recent a fire, the less of a percentage number of people from that fire have all of their stuff submitted.
Perfect. Thank you, Jerry. Okay, and then so really quick follow-up on that. Once a claim is submitted, does the client know what place in the queue they are for review and for an offer?
No, we don't know that. Once a claim is submitted, we're just told when an offer is ready.
Perfect. Okay, that's all the chat questions for now, Jerry. So we can open
Okay,
it up.
should we open it up?
Yeah.
All right, go ahead. I don't have access to it, so Guillermo, can you call someone?
Definitely. So if you have questions, just go ahead and unmute yourself.
I have a question.
Patrick Malone, go ahead.
Hi, Jerry. Jerry, I got a quick question. We're still waiting for the erosion report. Now, the Arbitrus, the tree report came back pretty quick, and we haven't heard anything on the erosion report. And that's pretty much all I need. That's all I have left to complete everything I need. So I was wondering if you've heard anything on that or what's going on with that.
Patrick, are you there?
Yes. Can you hear me?
Okay. Yeah, sorry about that. It just went in and out. Yeah, so I think the best thing to do is if you can send me an email, what I'll do is I will get in touch. We have a paralegal whose job it is to coordinate all the reports. Her name is Tatiana Southland, and I will have her reach out to the company that does these, and the specific hydrological engineer is Tina Sidzik. We'll get her estimate as to when that will be done, and then I can give you a better idea as to when we'll have Tina's report.
Okay, thanks, Jerry.
Sure thing.
Perfect. Who's next? Okay, Jay. Well, in the meantime, quick question. Would claims be paid out before attorney's fees calculations are determined? And is there any news on the 1099 issue?
Yeah, no, good question. So here's where we are on both of those. In terms of the claims and attorney fees, will they be paid out before? No, they definitely won't, because the way that it works is, remember, it's not that the trustee determines how much the attorney gets paid. All they're determining is how much they're going to reimburse the claimant. And so because that's an important part of the claim, that will need to be worked out before any decision is made. So that part, I think, is going to be required. And so that's why we're hoping we get that worked out in the next couple of weeks. In terms of the 1099, we had an extensive call with the tax attorneys for the trust, as well as the tax expert that we hired, an attorney out of San Francisco. And I think we made quite a bit of progress. The issue, it's a little bit esoteric, but it has to do with the interpretation of certain elements of the plan. And so this tax attorney, we believe, is not interpreting the plan correctly. And so what we are doing in order to get rid of this issue is now we're going back and we're bringing in the trust's bankruptcy attorneys and seeing if we can convince them that our interpretation is correct. If we can, great. If we can't, then we are going to go back to Judge Montali in bankruptcy court and seek a modification so that we can get the language that will be satisfactory to the trust attorneys. And if we do that, then we believe we can get it to where there will not be any requirement that the trust issue 1099s to the claimant for individual amounts. The trust will just issue a 1099 for the entire amount to the attorney, which is fine. We can deal with that. And then there's nothing in your name.
Perfect. Okay, Jared, we have somebody here with the raised hand, Ms. Wuzlik.
Go ahead. I'm sorry, I'm having trouble hearing.
Hi, can you hear me now?
Hi. Yes, I can.
Hi. I have never done this before, and so I don't know what I'm doing here with the Zoom thing, so I apologize in advance. But
No problem.
I'm one of the Butte fire victims.
Okay.
And, I don't want to sound like anything's more important. One set of fire victims are any more important than the other, which is not, although circumstances are. However, I have been led to believe that it was a first come, first served thing, so that the people like myself that have been waiting for 5 years to try to, for me, improve my land would be getting paid sooner. Is that not true? Hello?
There we go. How about that?
Hi.
Hi. Okay, great. Yeah, no, I just made it to my destination. So, okay. Yeah, it is actually not correct. There is no ability of the trustee to put any victims in front of any other ones. And that's why it's the first come, first serve. However, as we've talked about in some of the other meetings, if or when the trustee does make these initial offers, he's going to make them on behalf or for a large number of cases. So it may be 1,000, it may be 2,000, whatever it is. So everybody in that first group is going to be paid out at the same time.
Thank you. How do we find out or ascertain what group we're in?
Well, again, when I say group, I just mean that they're going to, make an initial group of offers. There's no official groups, but I can tell you whether or not you've been submitted. I can't tell off the top of my head, but I can find that out for you. So if you want to just email me, I can get the information tomorrow and then send it to you.
Okay, great. Thank you. I appreciate
thing.
that, Mr. Singleton.
Jerry, please.
Jerry, that's all I have. Thank you.
Okay, great. Okay, who's next?
Ms. Feel free to unmute yourself if you have a question. Ms. Gregg, do you have a question?
I have a question. It's Mariah Evans here.
Go ahead. Ms.
Please,
Evans.
yeah.
So regarding the questionnaire that I think it was on,
to me.
hello?
Yeah, go ahead.
Yeah, so the questionnaire, I think it was available on the website. I
Mhm.
printed it up and I kind of set it aside because when I spoke to Singleton, I asked about the questionnaire and they said that they're helping to construct filling it out as they interview us. I just
Right.
wanted to make sure that's correct or if there's anything else that I need to fill out as well.
No, and unfortunately, and frankly, I wish they hadn't done it this way, but the way they did it is that it cannot be filled out by hand, or manually or physically. It has to be done electronically. And
Okay.
so that's what's made it so difficult. And one of the things that's very frustrating about it is that the numbers are not consistent. It often goes, if you claim this type of a loss, then it'll give you a choice. But if you don't, then it'll skip ahead. So when we're referring to certain things, a lot of times the numbers are off when we're saying to a client, okay, how about this? And it gets very confusing. So if I were designing it, I would have done it very differently. That said, it is what it is. But from your perspective, you do not have to fill anything out. And unfortunately, even if you wanted to, you would not be allowed to do so. You would have to log in and do it that way.
Okay, would it be a good idea to just review the questionnaire to kind of see what pertains to each person as an individual and then just talk to the attorneys if there's something that, they feel need to make sure they cover?
Yeah, absolutely. And that's why we wanted to make it available to you, which is why, again, it's kind of frustrating to me that they don't just have a uniform numbering system so that you could look at it and say, how about this? But, again, it is what it is. So if you want to review it, and then if you have any questions about it or any specific issues you want to raise, that would be great.
Okay, thank you.
All right, who's next?
Jerry, this is Teddy Waters.
Hi,
How are you?
good, how are you?
I have a question. Have they decided yet what formula is going to be for the disbursement? I know last time, well, not even last time, but a while back, you guys weren't totally sure how that was going to work out.
No, they still haven't, and it all comes down to the budget. So one of the things, and in fact, we had a very lengthy and it was a little contentious, frankly, call where those of us on the Trust Oversight Committee really felt that the trust needed to come up with a specific budget. And one of the things we suggested is, look, why don't you set the budget very low, much lower than you think it'll be. And that way, if there's extra money, everybody will be pleasantly surprised. But let's set an initial budget so that we can start making distributions. Because if you don't do that, if you don't just bite the bullet and say, okay, we're going to assume there's going to be X amount and we're going to make distributions based off that amount, we could be here 6 months from now because we really don't know what that stock is going to do. So the suggestion that we had was set a very low number, something that there's no way we could get below 10, 11 billion, something like that, make all the distributions based on that. And then if we hit 13.5 or 14 or 15 or any of those numbers, then you can just give everybody an extra check on a pro rata basis. But if you do it that way, the bean counters, for lack of a better word, can come up with what the formula should be, how much of each claim they can award, and we can get it paid out in the next couple of months. We can start getting it paid out in the next couple of months. Obviously, it's going to take longer than that to pay everybody out. But that's what we feel needs to happen, because believe me, everybody on the trust committee feels the exact same way. We want our clients to start getting paid. And while we understand the concerns the trustee has, we understand the financial advisors, our view is if you set it very low, then you can at least get people something now. And if it, plays out the way we think and there's more money there, no problem. You can just make supplemental payments.
Yes, thank you so much. But what I was asking about was the original formula that you had that included the cost of cure and all that.
Oh, right. Okay. Yeah, no, cost of cure is definitely going to be used. Was your question about the 167% that in some cases has served as a maximum, or what were you specifically curious about?
No, I was asking about, originally there was a formula that whatever came up as your total would be like half of that, and then you would add more back to it. Do
Right.
you remember that one?
Sure.
That's what
Yeah,
I'm
you're
asking
talking
about, if that's still going to be used.
Right. That's the Trotter formula is what we call it. And it's economic damages, then 50% on top of that, then a small amount for non-economic. They are not going to use that. They're going to use a more formal approach where they go through and they break everything down. And that's one of the issues that we're fighting about right now, because we don't want them to have specific amounts for certain categories, because if they do, and they make that an official part of the award, then they would have to issue 1099s for anything that's taxable. Our view is if you come up with a lump sum, then there's no need to issue a 1099 to individuals. So that's one of the issues we're facing now.
Okay, that makes sense. Thank you so much.
Sure thing. Okay, who's next? Oh, looking at the group chat, let me answer these questions. There was a question, are our names and settlement amounts going to be public or confidential? They will be confidential. The total amount paid by the trust is a matter of public record, but the amount paid to any individual is not. That's absolutely confidential. You can share it with people if you want, but if you want to keep it private, then you have every right to do so and no one can share that. Let's see, the next question is, a little confused, is the questionnaire the same as the narrative we were sent? I think, if I'm understanding it correctly, and if this is not the right question, please correct me, but I think they are two different things. I think by the narrative, you're talking about the version of events and what you went through that you gave to our office. The questionnaire is the official document that we have to enter your information into so that the trust can make an assessment of your damages.
Jerry, really quick question. The
Sure.
client want to know, are we going to pay taxes on the amount we receive from the settlement?
Yeah, so that's a good question. Again, I'm not a tax attorney, so I can't give you official advice, but the general rule is that if you receive compensation for an economic loss, such as loss of real property or personal property, and you're going to use the money to replace that, then there has not been a taxable event, so there's no tax that's owed. Now, again, there's many, subparts of that rule and a lot of different things. So I would strongly encourage everyone to talk to a CPA or tax attorney, but that's the general rule. Now, there are certain types of damages. For example, non-economic damages where there's no physical injury that are taxed. And so because of that, we are trying to get the trustee to just issue one lump sum award so that each of you can sit down with your tax professional and allocate it appropriately, and then you can determine what the appropriate amount is for each category, again, in consultation with the tax attorney or CPA.
Perfect. There was a follow-up. Is there a pending lien? Will clients be notified before it is taken out if there is a pending lien?
Is there a pending what now?
If there is a pending lien, will the clients be notified before it is taken out from their total settlement?
Oh, yeah. You're talking about a lien. Yes. And what'll happen is this. The lien is going to has to be resolved before any payments can be made, because the lien holder has a right to stop the trust or the defendant or whomever has the money from making the payment. So those have to be resolved. The most common liens are medical liens, and the only pure liens are from the government, so Medicare or Medicaid. We can deal with those, and if you receive medical treatment and you have questions, let me know. But essentially, what it comes down to is if you received a certain amount of treatment and your insurance company or Medicare, Medicaid paid that out, then they're entitled to know or they're entitled to recover a certain portion of that.
Perfect. Thank you, Jerry. And I think Ms. Silverman has a question. She unmuted herself.
Sure, go ahead.
Hi, Jerry. Right.
Hi.
I understand why what makes sense on your end to, and even for your clients, to have it, the trust issue just a lump sum. But I'm wondering if for some people that might make it more difficult when there are numerous things that are involved in their claim to determine how fair the settlement is based on what it was valued at and compared to what the trust did in the various areas.
Yeah, that's the trade-off. And basically ultimately the way that I've always seen this work is that people generally, and again, every case is different and there are no absolutes, but generally most of my clients have a number in mind. And it's a net number to them. That really is what they're concerned about. So if they get that, then generally they're okay with it. If they don't get that, then that's when they would want to appeal. But you're right, doing it the way that we are proposing means that you can only appeal the total number. You can't say, well, I'm fine with X, Y, and Z, but I want to appeal A, for example.
Yeah, and it would be hard to know what they determined X, Y, and Z were. So you don't know kind of where you stand with that. So
yeah, no, it's absolutely true, and that is the downside. But at least from an overall perspective, the benefits of doing the lump sum, I believe, outweigh that downside.
No, and obviously you've given some thought to trying to figure that out. So if there is a lump sum, how would I'm not expecting you to execute this, but how would a tax attorney or yourself with a tax attorney figure out what portions of that were taxable and which weren't if you don't know?
Yeah. Well, and that's one of the reasons why we have such large economic damage reports. I mean, everybody who sees the reports, obviously they are very high, and they're that way for a couple of reasons. One is you want to anchor high. I mean, obviously you don't want to be unreasonable, but you certainly don't want to sell yourself short. So that's number one. But number two is it's incredibly helpful when it comes to taxes, because you have this professional saying that your economic losses are X, which are very, very high. And so your tax preparer oftentimes will make the argument, well, look, if that's what the professional says the losses were, when you take out attorney fees and everything, it looks like the vast majority of the losses were for these economic damages, which are not taxable. So that is another benefit, and that's one of the reasons we structure things the way we do.
Okay, thank you.
Sure. Yeah. Let me answer this one. It says, can you please remind us what the PG&E stock was when the stock entered the trust? Question number one. So let me answer that. It was just over 9. I think it was 9.01 or 9.02. So $9.01 or 2 cents. When is the stock being converted to cash? It depends is the answer. Right now, the payment of cash was well over $5 billion. It was just under $5.4 billion. So that amount is in the trust earning interest. So there's not going to be any need for those funds for quite some time. And then there's another payment in January that's due. And I can't remember if that is 600 million or 750 million, but it's one of the two. So there'll be another big chunk of cash coming in. So we won't need to monetize, sell off the stock until we run out of cash. So we want to hold on to it as long as we can because we believe it's going to keep going up. Again, and again, I haven't looked at it today, so I don't know where it is, but it was up quite a bit as of yesterday. It was well over 10. I want to say it was 1030 or 1040, something like that. It had gone up quite a bit. So we want it to keep going up, and we want to wait until after fire season and after the first quarter earnings are reported, which will come in January, before selling any stock, because we think that will cause the stock to go up significantly.
Quick follow-up question, Jerry.
Sure.
So to clarify an earlier question about confidentiality, the earlier pre-bankruptcy settlements had a requirement that the plaintiff keep the settlement amount confidential. Are you saying that's not the case with settlements from the trustee?
Correct. The defendant, PG&E, wanted to keep the settlements confidential, so they didn't want the plaintiffs to compare notes. However, there is no such requirement for the trust. So if you want to share, you can. You have that ability, but the trust cannot share your confidential information with anyone.
Thank you, Jerry. Is it possible to get a copy of the claim submitted by Singleton to the trustee?
Yes.
Okay, and are they still going to give preference because of age?
Yes, if you have, if you would qualify for a preference under CCP Section 36A, then they will, although again, it's a first come, first serve, so once you get it in, it should be resolved fairly quickly. By the way, on the Zoom group chat, someone said PG&E stock closed at 10:57 today, so that's great. That's up quite a bit, about I think 17% over where it went in. So that's a significant, and when you're talking about that much money, you're talking about several hundred million. That should be around 640 million, something right in there. Okay, who's next?
Really quick chat question for you, Jerry. Are tree reports considered economic damage, or is it just structural and personal property?
Yes, they are economic damages and they are real property. Remember, personal property is anything you own that is not affixed to the land. Anything that is on the land, so a tree, any kind of bushes, anything like that, or affixed to the land, a home, hardscape, fencing, outbuildings, anything like that is real property.
Thank you, Jerry.
All right, who's next?
Hello.
Yes.
Okay. You can hear me?
Yes, I can.
Okay. Okay. I haven't done this before. I
Sure.
have a question on what's the full amount of our insurance will be deducted from before we get our settlement. So for example,
Right.
AAA Part A dwelling has your coverage and then your extended coverage, and I know that's for sure deducted,
Mm-hmm.
the full amount. But what about under that category is also debris removal and replacement or removal of trees? Is that also going to be deducted?
It depends on whether or not you used that. So if you did, then it will. But if you didn't and you're not making a claim for trees or removal or anything like that, then it won't. It only, the only way they deduct something is if you're making a claim in that category.
Okay. I guess I need to talk to somebody in office and have.
Yeah, that's no problem at all. Just give us a call tomorrow and we can do that.
Okay, thank you.
Sure thing. All right, here we go. Follow up on a question from last time for a dependent settlement. Will the trust allow the amount to go into an investment account? Generally, yes. It depends on a number of things, but we've had success getting them into, for example, 529s, which can be set up for minors' education. If that doesn't work, then structured settlements pay more than the typical blocked accounts, which are less than 1%. That is a little bit of a fact-specific question. So maybe email me or call me, and we can talk about the specifics of your case, how much money it's going to be, and the condition of the minor. If, for example, the minor is disabled or severely injured, then they're going to require more protections than if it's a small amount and you wanted to put it into a 529, for example.
Thank you, Jerry. I think Mr. Haller has a question.
Sure, go ahead.
Yes, sir. So what is the going rate for a tree in Magalia?
Oh, it depends on a number of factors. It can range if it's, you know, an oak tree, a redwood. It can be tens of thousands, or, you know, it can be, you know, a couple hundred. It just depends on the type of tree, the condition, the size, the age, and the function it played on the property.
I'm not too sure very many oak trees were burned up in our area. I'm sure there were a few, but
Yeah.
you know, it's like I had 31 pine trees on my property, and now there are 0. So,
Yeah.
you know, just curious as to how they determine that and who determines it.
It's an arborist that does the determination, and they look at a number of factors. They would look at the function the trees played, what they contributed to the property, how the property has been changed as a result of their loss, all of those things.
Okie doke. Thank you.
Sure. All right, who's next? Well, we've been going for about an hour. Does anyone else have any questions? All right, well, hopefully we will have more information in the near future. If anyone has any questions, please let us know, call or email the office. And as soon as we have any information, I will pass it along. Thank you everyone for your patience. I know this is difficult, and I want to promise you we are trying to get this done as quickly as possible. All right, everyone, take care.
Okay.
See you next week.
Thank you, Jerry.
Thank you, Jerry.